Mr. Barner explained that evidently, according to Mr. Barner, Chris Brown came back. He came back to that complex. Supposedly, when everyone's there, Chris Brown comes back to that apartment complex. Did Mr. Barner explain that to you?
Yes.
Okay. But that still didn't make you want to go interview Chris Brown?
No.
Okay. Even though he's sitting at the Duval County Jail?
That's correct.
Ultimately, your decision in this case was you didn't feel you had enough evidence against Torgon Williams, right?
That's correct.
You did arrest Abdul Robinson Sr. for accessory after the fact, correct?
That's correct.
You did not arrest Leroy Whitaker for accessory after the fact, did you?
I did not.
But according to you, your evidence at that time was supposedly at the Buckley home. According to Mr. Barner, he was arranging for a car ride out of there, right?
That's correct.
You mentioned this, there was a rifle and a handgun found in the Nissan Altima, right?
That's correct.
Okay. And according to Mr. Barner, that rifle was Leroy Whitaker's, right?
According to him, yes.
Okay. Only according to Dominic Barner, right?
Correct.
I mean, you don't have any physical evidence, right?
Correct.
Okay. We've seen Instagram photos and such. Do we have photographs of Mr. Whitaker holding this firearm?
We do not.
In fact, I did not hear you testify, sir, to any kind of Instagram posts by Leroy Whitaker, correct?
No.
And Mr. Whitaker is not in this video that we saw of Charles McCormick dancing around, correct?
I'm sorry, of him dancing around?
Of Mr. McCormick dancing around, the video that you felt was
You're referring to
the bye, bye, bye video?
No, he was not in the video.
You never ended up doing any kind of a search warrant at Mr. Whitaker's home?
No.
Never spoke to his father?
No.
And the reality is, sir, after the arrest of Leroy Whitaker for murder in this case, after you laid out your probable cause, and you told us your investigation continued, right?
Yes.
But you never developed any further evidence that Leroy Whitaker had anything to do with the death of Charles McCormick, did you?
No.
I don't have anything further, Your Honor.
All right, then we are at this time going to take our lunch recess, ladies and gentlemen. It is 12:25, so I'm going to give you an hour, as I do every day, to enjoy your lunch. You may eat in the jury room, you may separate and go about your personal affairs, but whatever you do, you're not to talk to anyone about this case or let anyone say anything to you about this case. So please leave your notepads on your seats, and we will lock them, secure them, and return them to you when we reconvene here in 1 hour at 1:25. Thank you very much. Okay.
I'm making the request that if it's possible, that if you call them during the testimony, that the camera can be just point to the ceiling, it's not broadcast. But that accommodation has been made, I think, for some of the state witnesses, that they're not that their picture and their identity is broadcast on the news.
Okay. Well, that hasn't been done in this trial so far, just as an FYI. I have not prevented the cameras from filming the witnesses. Who specifically are y'all requesting that?
So of course, where our office did have a conversation with the cameraman, and so for instance, the lady witnesses, which included Kruger, Saunders, and Boston, the cameras were not focused on them during the testimony.
Oh, I was not aware of that. Okay. All right.
So that's the request I would make.
So that the cameras not show the next two witnesses, or?
No, Judge, I noticed that the close has to do is cross. I'm trying to just do timing and lining up, but I advised those witnesses that I would inquire of the court if that accommodation could be made. I was aware that it was done for those other witnesses.
Okay, well, if no one has an objection, we can we do that? I'm checking with my IT, because as you can see, we do not have an actual camera from the media in the courtroom today. The camera filming is coming from that camera in the back of the courtroom that we are controlling. So can we do that, Mike, in terms of not showing those two witnesses' faces?
Of course. Can you just let me know?
Of course.
Okay. Perfect. All right. Then if there's nothing else, we'll be in recess for an hour. Thank you. reported that at some point today during testimony or court proceedings, he made eye contact with a man sitting on this side of the courtroom and perceived what he thought was a threatening gesture involving the neck. We are pulling the cameras and the video to see if we can see it, but honestly, whether it happened that way or didn't happen that way, the victim or the juror has taken it as a threat. And so we can question him about it, but he has expressed his concerns to even be questioned in the presence of the defendants. So, Ms. Schlacks, I leave that to you, whether we question him privately in chambers outside of the presence of Mr. Whitaker, if that's something that you or he agree to, or not question him at all and simply excuse him and use your alternate number 1. I'm open to suggestions, but.
And Your Honor, I just want to clarify, this would be originally juror number 19?
Correct.
Is he the pastor? I'd be IT. Yep. Young kid.
right, please be sure the notepads you are collecting are yours if you are taking notes during this trial. Let me ask, as I do every time you return from lunch, and I realize this jury over here has chosen to eat lunch in the jury room with, I think, the exception of one person. But with you, ma'am, and the rest of you, ladies and gentlemen, during this lunch recess, did anyone approach you or attempt to speak to you or say anything to you or try to approach you in any way regarding this case? If so, please raise your hand. All right, and I see no hands raised. Did any of you on both juries, when your electronic devices were returned to you, read, watch, or listen to any television, newspaper, or radio stories that might have been printed or aired regarding this case? If so, please raise your hand. No, I see no hands raised. All right, ladies and gentlemen, then we're going to continue with the testimony of the witness, and at this time I'll call upon Defendant Robinson for cross-exam. All right, let me see court reporter and counsel at sidebar. All right, ladies and gentlemen, before we begin, I do want to apologize. It is now almost 2:15, and I know lunch ended 45 minutes ago, and here we are just starting. There are just sometimes matters that need to be taken up outside the presence of the jury. This was one such event. It's been handled, and now we will continue. I make every effort to see that your time is not wasted, that there are no unreasonable delays, and I do sincerely apologize for that, but there was a matter I needed to tend to. But with that, we will now call upon defense for Mr. Robinson to cross-examine. Thank you.
Thank you, Your Honor. Sir. Good afternoon.
Afternoon.
January 15th, 2020. You get assigned this case, right?
Yes.
You very quickly are able to develop a print that ties back to a firearm that was not used in the commission of this crime. Agree?
Yes, the day after the incident.
And that fingerprint was from my client.
Yes.
At that point in time, you'd agree that you start looking at Hakeem Robinson.
Yes.
You didn't know him before that.
No.
You didn't know of Ksoo.
No.
And you start looking at him.
Yes.
You as an officer, you would agree that you have to objectively investigate cases, right?
Yes.
Now, at that point in time, you already knew that Dominique Barner was involved to some extent, right?
Perhaps given the burglary incident.
What was the first warrant that you issued in this case?
For the car?
I'm asking you, you get that big binder in front of you, the very first warrant Now, to explain for the jury, when you want to collect evidence, there's something out there that you want to get. You have a judge sign a warrant, you type up an affidavit with the information for why you believe that it's relevant, and then you send it out and you get the items back, right?
That's correct.
Very first warrant that you do in this case has nothing to do with Dominique Barner, right?
No, not at that time.
It was for my client's Instagram account.
That was not the first warrant. The first warrant was for the car.
So you do remember now.
Just,
On February 5th, 2020, the first suspect that you send a warrant out for to collect information, not about a car, but to collect information, not to search the vehicle that we're not contesting here, was to collect records from my client's Instagram account, correct?
with respect to the question you asked, the first question you asked was,
Just answer this question now, please.
I am answering a question, but I'm going to basically say what I got to say. You asked me what the first warrant I got was. It was for the car. So then you then asked what the first suspect information I got was. Yes, it was for Mr. Robinson.
And we'll go back even further because I was talking about Dominique Barner. You didn't get a search warrant for any of his items, and you knew he was involved.
Not at that time.
Wasn't until months later. Right?
Right.
At that point in time, days after this happens, you're focused on Hakeem Robinson.
Yes, because I have the fingerprint in the car from the gun.
Now, you didn't have a fingerprint in the car. You had a fingerprint on a gun that was in the car.
Again, I said from the gun that was in the car.
Understand? Now, you've watched the entire Bang It Out music video, right?
Yes.
There's firearms throughout that, right?
Correct.
In fact, the one that the government is trying to say may or may not have been the one that was used in the homicide, it's held by a bunch of different people.
Correct.
You have no way of saying that the fingerprint on the gun that was found inside of the car was left on that gun even remotely close to January 15th, right?
No way, no.
Now let's talk about your investigation. Of course, you're shaking your head. I don't know if you had something to add. Okay. In your investigation, of course, you speak to the eyewitnesses, right?
Yes.
There was a young kid working at Hibbett Sports, pretty much right next door to where the murder happened. Jarvis Roberts, did you speak to him?
No, my partner did.
Okay, but you as the lead, when one of your colleagues speaks to somebody, that information, all of the information goes to you, right?
Eventually, yes.
And you combine that into your reports because you are the lead, right?
That's correct.
Jarvis Roberts, and I'm not going to ask you for what he said, but he gave a description of who he saw.
Without going to Detective Dishman's report, I can't exactly say what the report said.
In January of 2020, you authored a 59-page report that included all the reports of your colleagues, right?
Only the officers who did major case addendums.
There was also somebody else. There was a guy, Michael Williams. He was working out at the Baileys. He was on a Stairmaster. One of your colleagues spoke to him as well, too, right?
I believe I spoke to him.
And he gave a description of what he saw.
He did.
Now, we're talking about witnesses and who may have seen something. Abir Ahmad, who is a homeowner west of where the car crashed. We're not talking about the shooting, but the car crashes. 2 run eastbound, 1 runs westbound. She lives in that westbound direction, correct?
I believe so.
Right. And she saw somebody walking through her backyard. Right. I'm not going to ask you for her words, but she saw something, right?
I know she witnessed some part of it, but I don't have it in front of me to tell you exactly what.
All right. And again, we're just talking about people that I'm not asking you for their statements. One of your colleagues spoke to her, right?
Correct.
And they got what she gave as a description of what she saw.
Correct.
Renata Boston, right? Another witness.
Yes.
She saw somebody, correct?
Yes.
You got those descriptions.
Yes.
So, you're doing your investigation. You've seen the dash cam video by this point, right?
At what point is this?
Before the arrest of my client.
Yes.
All right. You have the dash cam video. It shows what it shows. You have these civilian witnesses that you've spoken to, and there was many more civilian witnesses, right?
Yes.
There was somebody that was pumping gas that could see, right?
Without telling you a specific name, I know there was one person I spoke to that was at the gas station.
So you had unbiased eyewitnesses, no connection to this case, not being prosecuted, give you a description of what they saw.
Yes.
And as you're investigating Hakeem, you haven't met him before.
No.
You have a description on what the shooter was like, and on the day that he comes into the station, was ultimately arrested, you met him for the first time, right?
Yes.
And you were surprised by how big he was.
Like his weight, yeah.
No, you were surprised with how big he was, height and weight.
I'd say weight. He looks a little skinnier on Instagram back then, from my recollection.
Would it refresh your recollection to see your reaction in the interrogation video?
No, again, I said there was the weight that kind of threw me off.
The day that you met with him, and this is for impeachment, the day that you met with him, there was a recording device in the interview room, correct?
Correct.
And at one point in time, he went out to go to the bathroom, right?
Without watching it, I don't remember.
And you walked back into the interview room, and he was in front of you.
Okay. I don't understand exactly what you're saying.
He answered the question,
Right?
and then
Your Honor,
Okay.
Sidebar, I disagree that it was answered.
All right, well, if you're going to show the video, only he is to see the video because the video is not in evidence.
Okay. It's for impeachment, but I'll show it to him.
But it's only to be shown to him
I'm sorry?
first.
Well, the only thing is there's audio, Your Honor,
Then I need to excuse the jurors.
or I can bring him over here and play it for him.
And the audio won't still be an issue?
It'll be very low.
No. I mean, I'm going to have to excuse the jurors at this point because then I also have to be able to see and hear it.
Understood.
And I won't be able to if it's low over there. So, ladies and gentlemen, I'm going to ask y'all to have a step into your jury room for a quick moment, and then we'll bring you right back out here.
Staying on the topic that we were on, September of 2020, was it? You first meet Mr. Robinson?
That's correct.
You're with Detective Dishman, your colleague?
Yes.
Never met him in person before?
Yes, sir.
Had spent months investigating this case, getting the descriptions of a shooter that was 5'5", 5'8", 5'9".
Sustained.
So, officer, there's CAD notes in this case, right? Call action detail notes.
Yes.
You've collected those, you've reviewed those.
Yes.
And your colleagues, as they were under the stress of the moment, were calling out over the radio the height and the weight of the person that they saw, right?
Yes.
And it wasn't just one, it wasn't just Officer Collins, there was another officer, Graham, right?
I vaguely remember, yes.
They both gave descriptions of the person that them as seasoned officers saw with their own eyes, right?
Yes.
You also have the civilians that saw the shooting, right?
Yes.
Mr. Robinson's in an interview room. You come into the interview room, he's sitting down, right?
Yes.
You talk to him for a minute, he hasn't stood up yet, right?
I don't know if it was a minute. I think he almost immediately asked to go to the bathroom.
Then he walks out and he goes to the bathroom.
Okay. Yes, sir.
Is that correct? I wasn't.
That's accurate, yes.
As he's walking back in, and this is the first time he's standing up, you make a comment, you're a lot bigger than I thought you'd be,
Yes.
right?
I said yes.
Not, you're the exact same size of the shooter that I've been investigating. Either consciously or subconsciously, you say, you're bigger than I thought you'd be. Right?
I've already answered this, but yes.
Please answer it again. They're not objecting. You don't get to make that choice.
Yes.
All right. Now, it wasn't just about his weight, was it?
It was about his weight.
Then why didn't you say it before he stood up?
I vaguely remember being in that room briefly. I don't think we made too many comments to each other.
If I'm sitting down, you can tell from my face, from my body, you can tell if I'm wide-shouldered, right? But you can't tell my height until I stand up.
At that point, I don't remember looking at his body. I was looking at his face, and then I think he asked to go to the bathroom. And then as he comes back from the bathroom, that's when I make the comment.
You agree that you made the comment?
Yes, never done that.
Yeah. My client was arrested that day?
Yes,
You didn't take any photos of him, did you?
we did not.
No. One moment, Your Honor. I'm showing you one of the government's exhibits. But you guys took photos of Dominique Barner. Multiple photos.
Yes.
So, understanding that we may have a recording, we could have had photographs just like this for this jury to see his exact size on that day.
Correct.
But you chose not to take photos.
With respect to Dominique Barner, the tattoos that he had at that date and time were the reason he was photographed.
Isn't the first photo with him with a shirt on?
Yes, they do overall photos.
Thank you, Your Honor. We're having a tech issue there for a second.
Okay.
So, this photograph, this is taken so you know who you're taking the photograph of, right?
That's correct.
There's no policy, there's no law, there's nothing saying that you couldn't have taken the similar photographs of my client, Hakeem Robinson.
No, there's no.
Be able to see what kind of weight he's carrying. Right?
Right.
You agree, though, that he doesn't have a single tattoo?
I have not seen the extent of his body, so I can't say that for sure.
Well, if there was tattoos, you'd be taking photos.
If they were described by a witness or a victim as it relates to the case, and it makes sense, yes.
Let's move on now.
Call action detail notes. Now, again, this is back in the day when they had the CB radio. Now it's digital radios. But anything that's going out there from all the different officers, it's going to a central location and being recorded, right?
Yes.
It's both typed out and audio recorded, right?
Yes.
So somewhere out there, there's an audio recording of two of your colleagues giving a description of the person they're chasing.
Yes.
Why don't we have that? Richardson hearing?
What? Okay, if I can have a grounds for the objection? Okay. I will overrule the objection.
There's an audio recording of your colleagues, literally as they're chasing after the person, going out on the radio. I need backup, I'm chasing somebody, and giving a description. Right?
At some point, yes.
At some point?
Yes, there would have been.
Okay. Now, both the call action detail notes and the recording, those are kept in the normal course of business for JSO, right?
That's correct.
They're created literally live, so they're created at or near the time of when the items are being reported, right?
Yes.
And they're organized and collected by somebody with personal knowledge about what they're doing. It's somebody from JSO.
Please, someone in the comm center, but yes.
Now let's talk about body cams. January 15, 2020, body cams were required for officers, right?
Yes, I believe so.
Officer Collins, although he was getting a rap at Publix, he was on duty that day.
I don't know if he was on duty or going to secondary employment.
If he were on duty and in uniform, he would have been on that date wearing a body cam.
He should have been, yes.
And per your policy, if somebody is chasing after somebody else in a vehicle and then on foot, they're supposed to activate that body cam.
Yes.
Now, obviously, sometimes that doesn't happen, right?
Yes.
But sometimes there are recordings, right?
Yes.
You as a lead detective, is there a recording?
Of?
Officer Collins chasing on foot the shooter?
No.
Doesn't exist or it can't be found?
I don't believe it exists. I asked for all body worn camera from that incident. I never had that.
Now, presumably, if that camera was on, we would have live images of the shooter, right?
Reasonably depending on when he got out of the car and what his body cam would call. I can't speak to that.
Let's go back to warrants now. Let's talk about search warrants. Now, you were looking at my client. You had probable cause basis to request those meta records, right?
Yes.
Did you ever search my client's residence?
No.
Did you ever search anywhere and find either the Nike tech suit that the shooter wore,
No.
the shoes that the shooter wore?
No.
You would agree that if you were to execute a search warrant on my client where he was living at that time at his mother's house, and that isn't there, that could lead to an argument of those aren't his clothes.
Potentially.
Now, these Nike tech suits, Nike tech fleece suit is what you think the shooter may have been wearing?
Sorry. Perhaps. Yes.
Right. Wildly popular. They're popular. Right?
I have seen them, yes, but I don't know how popular they are. Can't speak to that.
You're the lead detective. You didn't look into this?
How popular a Nike tech suit is at that time?
We're not talking about a unique, suit jacket covered in rhinestones. We're talking about Nike, popular brand, right?
Yes.
And their sportswear is big, both domestically and internationally.
Yes.
So what I'm getting at here is that there's more than one of them out there in the world.
Yes.
More than one of them out there in this county.
Presumably.
So it would be speculation to say that the one that we saw in the video with my client on the FaceTime call, that's the same one. That would be speculation, right?
Yes.
You don't even see the full thing.
You can't from the video.
Now let's talk about the posts. The shooter that you interviewed in this case, they covered up their appearance, at least their face, right?
Yes.
There was attempts to evade the police, to run from them, right?
Yes.
There was destruction of evidence. Some stuff was burned, right?
Yes.
You'd agree this is sort of like Crime 101. You get away with it, right?
I'm sorry. When you say crime 101, what are you referring to? Burning stuff?
The people that committed this crime, the shooter that covered their face, the people that ran from the cops, the burning of the evidence, the cell phones under other names, those are people trying to protect their identity, to hide it, right?
Yes.
Okay. So about a week later, my client posts on social media about doing something and getting his toes done. Right?
Yes.
And you believe that that's evidence of this murder?
In context of everything else that was posted, yes.
So there's all these attempts to cover up identity, and then he goes out into social media with, how many followers does he have? Hundreds of thousands?
Without looking at his page, I couldn't tell you.
You know that it's a lot.
Yes.
Right. That he then goes out there and confesses? That's your belief, that he everything is done to hide in the moment, and then 5 days later, I'll just confess to the world.
Yes.
That's your belief?
Yes.
All right. Now that statement, and I'm not going to repeat it like the government has a couple times. That statement, that could apply to anything, right?
As far as
If one of your say the government, one of our witnesses, and they have a riveting cross-examination. I killed him. I killed that witness. Doesn't mean they actually killed him, does it?
no.
Have
Not
you
in
ever
that
heard the
context.
phrase, for some people, I could only hope that someday my life is as interesting as I make it seem on social media. Have you ever heard that?
Can't say I have.
Now, you know that my client's an artist, right?
Yes.
You know from the videos and from the followers, right?
Yes.
Do you have any way of saying that he wasn't just co-opting the life that he saw growing up to sell records?
I can't say that.
Because who else would be stupid enough to post on Instagram, yeah, I just killed a guy, but the person that is trying to sell records to go, you know what? People out there are going to believe it because they don't know it, but I feel secure enough that I'm not going to be charged with this because I know I didn't do it. You understand the question?
No, if you could repeat it, that'd be great.
Have you ever heard the phrase, you can't be smart and stupid at the same time?
Can't say I have. I haven't heard that one.
It would be smart if somebody were trying to hide their identity in the moment. It would be stupid of them to then go onto social media and confess it if they were actually involved, right?
Yes.
Now, we're not saying that my client didn't like Willie Addison. We're not saying that my client didn't dislike Charles McCormick. But him disliking Charles McCormick doesn't mean that alone doesn't mean that he killed him, right?
No.
Posting, bye, bye, bye. That could just be a reflection of him disliking the guy, not necessarily killing him, right?
Right.
You agree?
Just the post itself? No, I agree.
This guy's dead. I mean, agreeably, it may not be tasteful. I don't like this guy. This guy is rapping about something, about somebody that me and others cared about. I don't like that. He's now been killed. Bye-bye. And you want to know what? I'll probably get a bump in records too. You agree with that? How about this? We'll move on. You can think up something. We'll come back to it, okay? Now, Charles McCormick. You know Charles McCormick was never a suspect in the Willie Addison murder, right?
Not that I'm aware of.
So he's rapping about something that he was never involved in. Right?
As of now, I did not investigate that case. I cannot say who was or was not a person of interest for that case.
You're being asked this question right now. Charles McCormick, to the best of your knowledge, was he rapping about something that he was never involved in?
As far as I can say, I can't say he had any involvement in that murder.
You can't say that he had any
I'd say
involvement.
that.
So it's okay for Charles McCormick, but it's not okay for the guy that actually has the record. Is that what you're saying?
It's not okay for the guy who has a fingerprint on a gun inside that vehicle that was used to murder him.
You already agreed with me that that fingerprint could have been left at any time.
It could have been, but there's any vehicle that could be tied to Charles McCormick, I can't say. I know you probably can't say as well, but I don't think I would be posting or rapping about something I might have remotely had anything to do with.
Let's go back to the fingerprint now. After you got that fingerprint, you didn't arrest my client, right?
No.
Because it wasn't enough.
No.
You didn't arrest Chifton Hogan,
No.
right? His DNA's in there.
I followed the evidence to verify where they were at that day.
You followed the evidence as far as the fingerprint and then just kept on that track.
The fingerprint and then the DNA when it came back.
The DNA that easily could have been transferred from the shirt that had my client's DNA on it.
I don't know the specifics of how it got on there. I can't tell you that.
Should we save that testimony for the DNA expert?
Yes.
All right. Now, let's talk about those civilian witnesses again. Renata Boston, she got vaguely a look at the person, right?
Yes.
Jarvis Roberts, right?
Yes.
Michael Williams.
Yes.
But Renata, it was something different because the person's hood was down, right?
Yes.
You never went out there with a photographic lineup to see if she could identify anybody, right?
No.
There's nothing stopping you.
No.
If she were to come back and identify the wrong person, your case would be toast.
No, not necessarily. I just have to if she picked out the wrong person, pick nobody, I'd verify who the person is that she picked and see where he was at on the day in question.
But it was never done.
No.
We don't know what we don't know.
She saw him, I believe, from the second floor.
No, she was sitting right there talking to her friend. She was sitting on the stoop. Saw the person come out of the woods. Was able to describe the hair, the skin tone. No photo lineup was ever shown to her.
No.
Now, let's talk about House of Pain. And you know the relevance here, right?
I'm sorry.
House of Pain 904 at gmail.com.
Yes.
You remember that, right?
Yes.
Okay. Now, you were born last century, right?
Yes.
I was born in the 70s. About the same age?
No.
House of Pain was big in the, you made me feel old with that one. House of Pain was big in the 80s and the 90s, right?
Is that the jump around?
Yep.
There you go.
Jump up, get down, that one. That's way after my client's time, right?
Yes.
But it's within the time frame of Blue, Abdul Sr.,
That's correct.
right? Now, you did look into Abdul Sr., right?
Yes.
His Instagram account is h.o.p_CEO, right?
Yes.
A bunch of stuff when you searched his house. There was a bunch of House of Pain paraphernalia, right?
Yes.
Are you able to say who that email account belonged to?
No.
Now, you could have found that out, right?
Perhaps, but then if they did the same thing that happened with the iCloud, where there wasn't like a direct name, then I'd still be dead in the water.
Let's do this. We got a whole box over there of Instagram records, call detail records, Meta, Facebook.
Yes.
You're the one that's the lead on this throughout the entire case.
Yes.
There's never a search warrant sent to Meta, that's Facebook and Instagram's parent company, to collect the records for HOP CEO Instagram account, right?
No.
Got it for my client days after the shooting.
Yes.
Never got it for that.
That's correct.
Okay. You could have also, you could have gone right to the source. You could have sent a search warrant to Google because it's a Gmail account, right?
That's correct.
And we could see, to get to the bottom of it, who this account belongs to.
Potentially.
Potentially?
I don't know what information that the Google account would have contained.
Now, all we know is that there's a few photos of my client that tie back to the iCloud, the Apple, right?
That's correct.
So you guys get the records from Apple, but not from Google and not from Meta.
I'm sorry, Meta. When you say Meta, we
Facebook, Instagram.
do have records from Facebook.
So Meta is Facebook and Instagram. You don't get records from them.
I do have, I'm sorry, you said I did not?
Let's back up. HOP CEO, that Instagram account.
Yeah, specifically that Instagram account, no, I did not get that one.
Okay, that's Meta. Now, for the House of Pain 904 Gmail account, you could have sent a search warrant to Google to get you could have seen all the emails.
Could have, potentially, yes.
You say could have. You had the basis to send out search warrants. You did it on everything else.
Yes.
You did it on the Apple account. It would have been the same thing. You just change out Apple for Google.
Yes.
But we don't have that.
We do not.
But you get the Apple account, and there's some selfies of my client, right?
Yes.
You're not able to say that Blue, Abdul Sr., who was admittedly doing some management for my client before he signed up, that he didn't have access to my client's Instagram, right?
I can't say that, no.
Okay. You can't say that my client, maybe was visiting, and I won't refer to him as his father, but Abdul Sr., he was seeing him and took a selfie on his phone. Right?
No, I can't say that.
Ms. Kawas and I are generally always together from work. If I were to take a selfie with her phone, that doesn't mean that's my phone.
Right, but generally, most of the photos on that device would have been of her, not you. I'm sorry, does that make sense?
It doesn't. What we're talking about, though, is who the House of Pain email account belongs to.
Correct.
More work could have been done to other companies to find out the answer to this.
Again, as it relates to the House of Pain, yes, I could have subpoenaed, I guess, Meta to see if there's any other accounts tied to that account email.
So, but when you see a selfie of my client from the Apple return, it's just, okay, that's good enough. That's his account.
It wasn't just a selfie, it was multiple pictures, but okay.
We have the evidence. There's about a dozen photos, right?
Yeah, there's multiple photos.
Dozen.
Still multiple.
Okay. My client's phone, the 1595 that we have in evidence, how many thousands of photos are in that?
It's different. I have the entire device. I don't have the entire device for that 478 number.
At the end of the day, you cannot confidently say who that email address belonged to.
No.
House of Pain 904 at Gmail.
No.
Let's talk about Raekwon Howard. Now,
You've seen the meta records for Raekwon Howard, right?
Correct.
now, we have to assume that that's actually the Raekwon Howard's Instagram, right?
Yes.
You've met with Raekwon.
Yes.
He's next door in the jail right now.
I don't know exactly where he's currently being housed, but I know he is in jail somewhere.
Now, Raekwon Howard at one point in time tried to kill two of the witnesses in this case.
That's correct.
It's the next question, Your Honor.
Okay, I'll allow one more question and see if you can type relevance.
Never tried to kill my client. Right?
I don't know what all he's tried to do.
So let's back up to make sure that we're clear. You answered yes, that he did try to kill witnesses. He tried to kill Torgon Williams and Natalie Gant.
That's correct.
He's been charged with that.
Yes.
You know of no time when he's tried to kill Hakeem Robinson.
No, I can't say so.
Now, the relevance here is that these warring factions on the street, that they don't get along, right?
That's correct.
All right. That could have been payback for the murder of Charles McCormick. Happened months later, right?
It did.
Okay.
So let's get into the meta records of Raekwon Howard, or somebody that could be Raekwon Howard. We'd have to hear from him to know that these are his records, right?
There's several pictures of him on that account. The email address is RaekwonHoward4.
Are you saying that Raekwon is a unusual name?
I don't know, without looking it up, I don't know how many Raekwon Howards are in the world.
Didn't Raekwon Howard try to kill another Raekwon? If you know.
I don't know.
All right. Give me 1 second, Your Honor. I've got to DJ over to another screen. I'm getting better at it. No, we're good. We got it here. Okay. I'm going to wait to publish it. I don't want to show it yet. Okay, let's just jump into this. Let me know if you can see that on the screen.
Yes.
So what I'm showing you is admitted into evidence as a state's exhibit. Unfortunately, I don't have the number, but I'm sure that either Ms. Kawas or the government can tell me what it is. Raekwon Howard's meta records. Meta records.
Oh, yeah, this one would be Hakeem's. The whole thing. Huh? Hold on, Joel. Yeah, we'll enter the whole thing. Yeah, that's fine. So, you've reviewed these records, right?
Sorry, yes.
All right, now what we're talking about, we're going to focus on Hakeem Robinson's records.
Okay.
His meta records, you've reviewed those because you received them, right?
Yes.
Raekwon Howard.
One of his usernames is rpg.poppy.
Yes.
Now, there's several other names, but that's one of them, right?
Yes.
Now, the records that you get, it's only for a small period of time.
Yes.
And within that, you looked at the communications, the volley of communications in December before the murder, right?
I believe so.
And then after it.
Yes.
In December of 2019, my client's having conversations. They're texting back and forth and speaking, both my client and RPG Poppy. Would it refresh your recollection to take a look?
One moment, Your Honor.
Stated starting on page 5,969. Do me a favor. You take a look. Scroll down there. I want you to start on, you'll see the username highlighted.
Let me move this just so I have someone to kind of place that. Oh, knock it down.
Just let me know when that helps your memory.
All right.
Does that help your memory?
Yes.
Can you replace the microphone back where it was? Thank you.
In December, the month before the murder, they were talking regularly, right?
Yes. Sorry, 1 second. Yes,
One of the comments was LMFAOOO,
it was.
right? There was another comment about somebody losing weight.
Vaguely remember that, but yes.
Now, these communications continue through the time of the murder, right?
Yes.
And up until the end of the records, which were about a week after the murder.
From the best I remember, yes.
So it wasn't uncommon for my client to be speaking to Raekwon Howard.
No.
Your belief is that my client killed one of his people, one of his group.
Associate, maybe, yes.
Doesn't that prove more that my client is not part of all of this? That he's not at war with this group like the others that are involved? They can't give you the answer.
No, sorry.
You got to look at me.
He stood up, sorry. No, I don't know, just without knowing all the context of their conversations, I don't know what they're saying to each other.
You saw the text messages.
Yeah, I saw them teasing each other, but that doesn't necessarily mean that it's not still bad blood there. I think it's weird that they talk as much as they do. I'll give you that, but it doesn't mean that they wouldn't have it.
Let's break it down. You view my client, and you're like, he killed somebody that's part of this group 6 block. It's weird that he's talking to somebody from 6 block, right?
Yes.
Doesn't that weirdness go away when you finally admit, oh, wait, maybe my client didn't have a problem with this group 6 block, and that was everybody else that was still battling on the streets?
I'm sorry, repeat the question.
All right. You think it's weird because you believe that my client has this problem with all the group 6 block, right?
Yes.
Doesn't that weirdness, that weird feeling you have, doesn't that go away?
No.
You admit that.
And the reason
I
that
gotta ask a question.
Sorry. Go ahead.
All right, we just need one person speaking at a time. So let the attorney ask the question, and then we'll let the witness answer the question without interruption on both ends. Go ahead and ask your question.
Doesn't that weirdness go away if you realize, wait a second, if Hakeem gets along with Raekwon and they're even joking around, and you can't speculate whether it was positive or negative, that maybe he isn't part of this rivalry in between the two. That clears up the weirdness.
It does not, because he mentions Bibby almost every chance he gets.
Sidebar, Your Honor?
Okay, let's come sidebar. All right, thank you. Ladies and gentlemen, we're back on the record. We're going to take another restroom break. There's been a request for a bio break, so I'm going to ask y'all both of the juries to step back into the jury rooms for just a short while, and then we'll bring you right back out here. And we will continue with the cross-examination of the witness.
But Dominique Barner, right?
Yes.
You eventually arrest Dominique Barner, right?
Yes.
And he later decides to cooperate with you, right?
That's correct.
You're there for the day that that's memorialized.
You mean when the sworn was taken?
Correct.
Yes.
It was taken at the station, the same place that you spoke to my client, right?
Yes.
Okay. So let's talk about that.
The statement that you refer to, that happens in a room where it's being recorded, right?
The sworn, yes.
You're in there?
Yes.
ASA Joel Cooper's there?
Yes.
Dominique Barner
Yes.
and his attorney.
That's correct.
Now, before that recording ever takes place, you have a pre-meeting, right?
Vaguely, yes, that's fine. Sorry, that was just a matter of the terminology. That's it.
Give us.
We say a pre-meeting, it's just a meeting.
You have a conversation with Dominique Barner, who's now about to become a witness in a case, and the very first meeting that you have where all of you are in there is not recorded.
That's correct.
Then you go into the room and you do the recording.
Yes.
All right. You're in the room for that conversation.
Yes.
ASA Cooper is asking the questions.
Yes.
Now, I want to make it clear that I'm not trying to argue that they told any witness what to say. Okay, so I'm prefacing it, I'm not saying that. But the questions that were asked in that room, they were in a leading fashion, right?
I'm sorry, when you say in the room, you talking about the meeting or the sworn?
The sworn statement, the one after the rehearsal where you're having the conversation, it's recorded, and if you need to review it to refresh your recollection, let me know. But the questions that are being asked are leading questions.
For the most part, they're just yes or no questions.
Yes or no for Barner to say yes or no.
Yes.
It wasn't a situation of, Mr. Barner, we have the camera, tell us what you know.
No.
You believe from the cases that you have that Dominique Barner is a dangerous person.
Yes.
You also know that this guy, he's smart, right? Not book smart, street smart.
To an extent, yes.
He's the one that figured out, I'm going to go onto Core, the Core computer system, find a case for Charles McCormick to figure out an address, right?
Yes.
He also had fake Instagram accounts to track him when he was on vacation, right?
I was not aware of the fake Instagram account, but
You know that he was clever in the ways that he figured out how to hunt Charles McCormick.
at times, yes.
Are you saying that he is not clever enough to figure out what it is that y'all want to hear?
I couldn't say that. Again, everything that he's told us was corroborated by the evidence that I had.
Now, if I sit down and I'm in that room instead, and you're Butter, and I ask you and I go, is there a phone call in the car and I'm holding a stack of papers? You as Butter, you could be like, yeah, that could happen, right?
If I led with a question like that, yes, I say.
So what we're saying is that this person that wants a deal, that knows what you guys want, is it beyond this known murderer's ability to craft his statement in line with your facts?
Again, all we ever asked him for was the truth, and that's what he told us.
And we have to rely on him whether he's truthful or not.
Yes.
You do know that he's taken lives.
I'm sorry?
You do know that he's taken lives, right?
He's taken lives?
Yeah, sustained.
Through your investigation, you knew that Dominique Barner was involved in the Rothermill case, right?
Yes.
Okay. Safe to assume that you would be of the opinion that he's a dangerous person?
Yes.
Okay. What's harder, shooting somebody or lying?
What's harder?
Yeah.
I'd say shooting somebody.
So now, let's stay on this topic of the way that you do the conversation, then the interview. Later in time, you spoke to other people. You spoke to Torrigon Williams under the same parameters, right?
Yes.
But you just chose altogether, we're not even going to record this one. Right?
I didn't choose that. I don't take sworn statements.
All right. You were there.
I was there.
There's no policy that says you can't do it.
When it's an agreement between the two attorneys and they're facilitating this meeting, we met under the pretenses that they had already established.
There's no law that says that you can't record, right?
No, there's not a law that says I can't record, no.
Police can actually surreptitiously record things, right?
Yes.
But you're saying that the prosecutor, not you, but the prosecutors in Torregon's.
Yeah, I'm just short leash here on relevance. I think we're going down. I'm going to sustain the objection.
When you're speaking to motivated witnesses, we spoke before about Dominique Varner, that it wasn't a situation that you went in there with a recording going, tell us what you know. That it was instead leading questions. Now we're moving on to Torregon Williams, somebody else. Torregon Williams is involved in this, right?
Yes.
You're having a conversation with him, and I think what you said is that the attorneys, not you, agreed to not record it.
Sustained.
We don't have a recording of that conversation.
Of a conversation with Torgon Williams?
Correct.
Correct.
So we don't know the evolution. Counsel? We don't know the evolution of his statements, both pre-interview, the interview, we don't know any of that.
I'm sorry?
I was objecting again, same line of question.
Okay, I'm going to have to see attorneys at sidebar. Let me see court. If the court reporter's ready, you may continue. Yes.
She gave me the nod.
All right, very good.
Remind me, colleagues of yours or yourself spoke to Raekwon Howard, right?
Yes,
That too was not recorded.
that's correct.
Let's talk about Natalie Gant. I'm showing you what's been entered into evidence.
One of the state's exhibits. What's Natalie Gant's phone number?
I believe it's 904-485-7529.
And you've reviewed the cast report from the FBI agent, right?
Yes.
You recognize that, right?
There we go. Yes, sorry.
7529.
Yep.
Are you sure that's actually your phone number and it's not 7259?
Let me strike that. Would it refresh your recollection if I were to show you the subscriber info and the call detail records that you received?
Yes.
Your Honor, may I approach?
Yes.
Do me a favor. You're gonna go, if you're an Apple guy, you'll know.
1 second.
Here, I'll hold it.
All right.
And you're gonna go back and forth between the two. So you can go like that. Then like that. Yep. If you want to.
No, sorry.
It's the wrong phone number, right?
Correct.
It's not 7529, it's 7259.
Correct.
Now, when dealing with a homicide investigation, accuracy is important, right?
It is.
If you bring an FBI agent to testify about the plotting of cell phone records, you need to make sure that you have the right number, right?
Yes.
Now, mistakes happen. This is incorrect, right?
That isn't.
7529 is not Natalie Gant's phone number.
Right?
Yes, that's correct.
7259. No question from your investigation in this case that she was involved, right?
That's right.
She was never arrested.
No.
Now, the government asked you a line of questioning about Chris Brown and DNA that was inside of the car, and how Chris Brown's DNA wasn't inside of there. So I'm just giving you a heading of where we're going. Dominique Barner's wasn't found in there either, right?
It was not.
In your conversation with Dominique Barner, specifically that interview, he tells you that Chris Brown was involved, right?
I said yes.
He says, well, Chris Brown was a lookout.
Before he left, or I don't know if you call it lookout or verifying the car information.
But Barner let you know.
And I'm not saying that Barner said, he let you know Chris Brown was involved.
To an extent, yes.
You went, you tried to speak to Chris Brown like you did with Torgon Williams and Raekwon?
I'm sorry, repeat the question?
Did you go and
Try to speak to Chris Brown like you did Raekwon Howard and Torgon Williams?
Oliver, if that's the question, is there an objection to that question? Did he speak to Chris Brown? Okay, then you may proceed to answer the question.
Did you try to speak to him?
No.
Your Honor. Sir, I'm showing you what's been entered in as defense 1. Should be popping on. Oh. It's showing it.
And nothing's on any of the monitors.
Well, it's up at the top, but it's not showing at all.
No.
You can see like the time right at the top, or at least you can here. Oh, I'm plugged in. Full source.
Screencasting settings for. Okay.
Where do you want it at? It's still crest on. There we go. Just took a minute, Your Honor.
Okay.
Showing you defense 1. It's Chris Brown, right?
Yes.
Butter pecan skin.
That is your judgment on his skin color, sure, that's fine.
This photo could have been put in a photo lineup and shown to Renata Boston, correct?
Correct.
Did you ever acquire? Now, Dominique Barner has already said he was involved.
That's a crime, right? What Dominique Barner told you makes him an accomplice, a co-conspirator, co-defendant.
Yes, to an extent.
Now, the gradient on that, the extent, the spectrum, it's still pretty high on murder, right? Even on the low end.
Can be.
You didn't request any phone records for Chris Brown?
Never found any phone numbers connected to him.
I'm sorry?
I never found any phone numbers connected to him.
You never tried to find any?
No, with respect to the rest of the evidence as far as cell phones are concerned, no.
No social media?
Sorry, no.
No social media?
No.
No search warrants?
No.
Nothing. You collected nothing on this man that Dominique Barner, your star witness, you collected nothing on this man.
No.
Now, again, we're not getting up here and saying that it was Chris Brown. We're talking about objective and withdrawn, Your Honor. There was other people who would have had a motive to kill Charles McCormick, correct?
I can't speak to who wanted to kill Charles McCormick.
You investigated this case, right?
Yes, but I can't just say a group of people wanted to kill him.
There's a music group that you know to be known as ATK, right?
Correct.
There's more people that are affiliated with that group than have been mentioned during this examination, right?
Correct.
We know that there are multiple people in things like the Bang It Out music video, right?
Yes.
Those people very well could have a motive to also dislike Charles McCormick, right?
Could, but I can't be a spokesperson for ATK and what they would and would not do.
Malkeith Worthen,
Okay. Yes, sir. That's me.
a.k.a. Ksoo, did you look into him?
No.
Somebody that goes by the name of Sosa, did you look into him?
No.
Keonta Bullard?
No.
There's a whole bunch of other names, right?
Yes.
And any one of them could easily fit the description of the shooter.
Without literally sitting here looking at shut photos of them, I can't say. Sorry.
You didn't get any records for any of them?
No.
Didn't investigate any of them?
Nope.
From February 5th, 2020, possibly before that, you were focused on Hakeem Robinson.
And I'm sorry, say the dates again.
February 5th, 2020, when you sent out your first search warrant against a person, not against a vehicle.
To what date, sir? I'm sorry. I thought you were saying the date range, just why I'm confused.
Okay. We'll move on.
Okay.
Let's talk about the government's exhibit. This may take a minute again. So on direct examination, you were shown some color-coded phone calls. It will take a minute to pop up here. Now, you were shown a series of phone calls. You remember these?
Yes.
And I think your words were there was a lot of activity, of a lot of communication, right?
Yes.
Now, the first one here in red, that's a conversation between, and correct me if I'm wrong, it's real small on this screen, between my client and his brother, Abdul Jr.
Can you like zoom in like a tad bit? Sorry.
And what exhibit is this?
This is 10F, States 239.
Okay.
So, sir, I'll make it easier for you. You'd agree that the communications with red is the state's belief that it involved my client, right? And what I can tell you, what I see here is that it's a conversation in between the number ending in 3604 and the known number for my client ending in 1595.
Yeah, yes, but I just asked you to zoom in just a tad bit. Sorry. If you can, it's okay.
I think I can. Give me 1 second. That's what I didn't want to happen. So, unfortunately, it doesn't give me the ability to be able to do that cleanly.
Fair enough.
I'm going to try to do it again. You see it any better now?
Yes, there we go.
Okay. So, that is a phone call in between my client through his known number and his brother, right?
Yes.
And then you testified on direct that there was a lot of activity, in and around the time of the murder, right?
Yes.
No red.
No red. No, sir.
No red. None.
Not in the pages that are on my screen.
All these people talking back and forth. Dominique Barner. Right?
Yeah,
Abdul Jr., Torgon Williams. No red.
No red.
One of the items that you have in evidence in this case is my client's actual phone for the 1595 number, right?
Yes.
You've looked through that.
Yes.
You've looked at the notes that are in there as well too, right?
The notes are kind of hard to look at on the Cellbrite reader.
So, I'm now going to show you what's been entered in as state. We've got Exhibit 9U 229. All right. Now, the government entered into evidence these notes, but there's no date or time. You see that?
No.
It'll pop up in it takes a minute to transfer. You see that, right?
Yes.
No date and time.
That is from the iCloud return.
But if you were to access the actual phone that we have here in court, you can see the actual date and time of those notes, right?
Potentially, if they still exist on the device.
All right. So, for instance, this first note, if we look into the phone, December 4th, 2018. Would it refresh your recollection to take a look at the phone?
Yeah, because I don't even see where you're getting the date from.
One second.
Yes.
So type that. Take a look at that note. Let me know if that helps.
Okay.
Does that refresh your recollection?
Yes.
So this first one, the one that the government entered into evidence, Real killer, I'm a hunter, you don't want to see me with a gun. That's actually from December 4th of 2018.
According to the note section, yes.
Do you know if any of those notes are within even a month of the shooting of Charles McCormick?
No, because I left to look at it through the Celebrate reader.
More so than the actual phone?
Yes, because that's what we go by, is the Celebrate reader.
But this is the Celebrate report, right?
Yes,
It says Celebrate.
but that's the iCloud, and I don't know, I'm just speaking, I don't know if when it backs up, if it saves the dates. I can't speak to the efficacy of the backups.
So what we're showing you on the screen right now is the government's exhibit. You see Celebrate in the top right-hand corner, right?
I do.
There's no dates, there's no times, right?
Yes, and again, that's the iCloud warrant return.
Now, the whole purpose of Celebrate for the jury here is this, that cell phone, you're able to view it because it has an operating system, right?
Yes,
And so it organizes the information, right?
correct.
Now, when you get the information, the data from Apple, you need something to interpret all the data, right?
Yes,
And because you use PCs, you're not using an Apple iOS device operating system, you have Celebrate to understand and organize the information.
it puts it into a readable format, yes.
But it's still the same data.
But again, what I'm saying is it's an iCloud warrant return, so I don't know if it saves the dates and times when stuff was created.
All right. You have Celebrate in front of you, you have the actual phone.
Yes,
All of the information you have shows that it was December 4th, 2018, right?
for the phone, yes.
Now, I'm not going to go through each one of them, but I will ask the question. Do you know if any of those are within a month of when the murder happened? Any of these notes in here?
I can't tell just from looking at the Celebrate reader.
Did you also search that phone for
Any emails whatsoever for houseofpain904@gmail? Let me strike that, let me ask it in a different way. You've already said you reviewed the phone. There's nothing in there, even for emails that go back 5 years before the murder, that tied to houseofpain904@gmail.com.
Not that I recall.
Now, let's go to the one second for this to toggle over. Now. It's with him. So I want to now I want to make sure that this is not zoomed in. You remember on direct examination talking about the IP address, right?
Yes,
How you recognize that IP address.
correct.
Okay. So within the meta records, now at the same time we're showing this, but we're also talking about the meta records.
For my client, you can see the IP address that was logged into during the time of the murder, right?
Roughly, yes.
Okay.
If you need to take a look at it, let me know, and I can refresh your recollection with it, okay?
Okay.
But you remember taking a look. Sec. You remember taking a look in that's what? 32 characters? Roughly for an IP address?
Roughly.
And that's a unique thing that's tied, like this computer right here, IP address. This laptop that I have, IP address. This phone, IP address. Right?
Yes.
You know from the medical records a unique IP address that my client was using during the time of, so basically, you can see that he was logged into his Instagram account under a certain IP address.
It has upload IP addresses as well.
Not that IP address.
Literally, without looking at it, I don't have the whole thing memorized.
Would it refresh your recollection to take
Yes.
a look? Okay. second, Your Honor.
Counsel, page 6 of 6,717. So let me do this, if you need to reference it. I'll take the phone because the state wants it. On January 15, 2020, was my client logged in to Instagram, and do you see an IP address?
I do.
The IP address that you see in the meta records that are
Your evidence, it doesn't match the IP address of that upload, right?
From the information I got from T-Mobile, the first 4 of those little brackets you see are from the carrier itself. The last brackets are from the device. So they don't always match up. So the most important characters are the first 4 brackets you see there.
Now, you just brought up that you got a response from T-Mobile. You actually got what's called an objection back from T-Mobile, right?
Objection? I don't.
If I can approach.
Okay.
You actually requested from T-Mobile for any information with respect to the IP address from the meta records, right?
For that, but I had to, again, go ahead.
That's a yes, right?
That's yes.
Now, what you were asking for is T-Mobile. You have this 478-305-9583 number. Do you tie that at all to the IP address of my client and his meta records?
I believe that IP address is in there. I can't, without using the data records to refresh my memory.
T-Mobile responded to you and said no, right?
Right.
We don't have any record of that.
But again, it's the first 4 blocks that are the important ones from my understanding.
The IP addresses do not match, correct?
Not the entire thing, no. But again, what I'm trying to say is the first 4 blocks is what they told me was the important part, that the carrier themselves had in their records. That makes sense. But that particular one, okay.
You asked T-Mobile about that, and in response, they said to you, no records were found.
For that's a different IP address. And that one, I'm sorry, the one that's currently on the screen for everybody to see, that one appears to be different because it's 2607, not 2601.
Do me a favor and I'll re-ask the question.
Yep.
You see that?
Yep. No, what I'm saying is
Hold on.
yeah. Yeah, because again, that's 2601, not 2607. It's different. That's the issue.
My question is to you.
You communicated with T-Mobile, and we're trying to find out if they had any connection between the IP addresses, and the response that they gave you back was no.
And again, the reason is it's 2607, not 2601.
So are you saying that you made a mistake?
I'm human. It happens. I don't know if, but again, without looking at the actual subpoena request, I don't know if I provided them with the correct one and they gave me that. Again, I haven't seen it.
Of course you followed up with the correct IP address,
Yes, I should have.
but you don't know.
I can't recall it this minute. Again, this is 5 years of investigating work.
So as you sit here today, you have no way of saying that my client ever was logged into Instagram on that phone number 478-305-9583.
And I'm saying that the objection letter that you just showed me was 2607, not 2601. So the IP address is different, is what I'm saying.
I get that. I understand you requested the wrong one, but you never followed up and got the right one.
I believe I did. I got a 47. I'm telling you, I got a record from that, the IP addresses.
Sitting here today, you can reference no piece of evidence that ties my client definitively to that phone.
Without going to, again, as I said, I've done an iCloud search warrant for the House of Pain. I've seen all the photos attached to it. Literally where I got that number from was from the IP addresses, from the Instagram account for Ksoo 23X. So that is how I tied it back to him.
We're talking about the IP address for my client's Meta. Of course, it's going to tie back to him. What I'm talking about are connections over to the 478-305-9583. Sitting here today, the only thing that you can reference is the House of Pain email, which we've already discussed, right?
Yes.
One brief moment, Your Honor.
All right. All right, is there any redirect?
Are you using what's on the Alma? Because if not, I want to return to the clerk. So,
Introduce the fund. Did you have an opportunity to look at it? Is this now that we've got it?
Sergeant, may it please the court? I'm sorry.
Yes.
Thank you, Judge. So, turning to the screen in front of you that shows that YouTube video that defense counsel was just referencing,
Yes.
you just see the IP address for the upload IP, correct?
Yes.
All right. And the first four digits or first four groupings of numbers are what exactly?
Sorry, 4 digits.
The first four groupings, 2601 colon, and then what's the next set of groupings?
344 colon C000 colon A990 colon.
And I think you were explaining or attempting to explain when you spoke to T-Mobile and you got records associated with requests that you sent in, you were also advised for an IP address what was the most pertinent part of the IP address. Is that correct?
Overruled.
You can answer.
Yes, the first 4 blocks are the most important
And what is your understanding as why the first four blocks are what you need to look at?
because the first 4 are assigned by the carrier, and then the last 4 come from the device itself.
And does the device itself, is that allowed to randomly pick the last 4 groupings of numbers as part of the IP address?
outside the scope of knowledge, this isn't an expert.
Yeah, if he has no personal knowledge about it, then I'll sustain the objection, but you can inquire to see if he does.
Do you have personal knowledge as to how the last 4 groupings of numbers are assigned?
From the record response I got from T-Mobile, that is what was indicated to me,
Which was what?
that the last 4 assigned by the device can be random.
I'm sorry, the last part I couldn't hear.
Last 4 can be random.
It'll be random, okay. So the first 4. So that specific 4 groupings, 2601 colon 344 colon C000 colon A9990. You've seen that IP address before, correct?
Yes.
Right. And going back to Hakeem Robinson's Instagram account, the Ksoo 23X, where did you see that specific first 4 groupings of numbers for an IP address?
I remember it seen on the login IPs.
Do you recall the nail salon video posting?
Yes,
All right. And was that on January 20th of 2020?
it was.
What was the first 4 grouping of numbers for that IP address?
It's the 2601 344 C000 A990 that you see there.
All right. And when you reviewed those Instagram records and saw those first 4 groupings for the IP address, is that what made you then send in subpoena requests trying to identify phone numbers associated with that IP address?
Yes.
Right. And as a result of the records you obtained in response to that, what phone number did you identify?
478 305 9583.
And then you sent record requests to what company?
Apple.
And is that when you got the House of Pain iCloud account information back?
Yes.
Do you recall on direct a long time ago when you were looking at the cell phone records?
Sustained.
I apologize.
Well, I haven't heard the question.
When you were looking at the cell phone records for these phone numbers, 478 305 9583, do you recall doing that?
Yes.
Okay. Do you recall when that phone number was activated?
The date it was activated was 11/12 of 2019.
When was the House of Pain iCloud account activated in relation to that? Do you recall?
I believe it was the same day.
And so when you were asked a bunch of questions about House of Pain Gmail account and not seeing any of that on 704-1595 number related to Hakeem Robinson going back 5 years, the House of Pain iCloud account didn't exist 5 years prior to that date. Is that correct?
That'd be correct.
So it didn't come into effect, I believe, you said until when?
11/12/2019.
Now, when you reviewed the iCloud account associated with House of Pain, you were asked about photographs and videos and selfies. And there was, I believe your testimony was there were multiple selfies and photos. Is that correct?
That's correct.
Now, you looked at hundreds of photos and videos on that iCloud account. Is that correct?
Yes.
Now, were all of those photos and all of those videos, did they all contain Hakeem Robinson?
For the most part, yes.
And it was either, let me ask it this way, were they either selfies or included Hakeem Robinson with someone else?
Yes, sir.
And so it's not just a couple. So,
Okay, sustained.
is it more than just a couple?
Yes.
In fact, it's hundreds.
Objection, lead in.
Sustained.
Is it hundreds?
It was, yes.
You were asked questions about the 704-1595 cell phone number attributed to Hakeem Robinson, and I think you were shown some records showing activity on January 15th, 2020 in the morning. Is that right?
Yes.
Do those cell phone records show whether or not FaceTime calls were made?
No.
So that's not contained within call detail records?
Objection, lead in.
Overruled.
Is
No,
it,
I'm sorry, say the question again.
are FaceTime calls contained within call detail records?
They're not.
Are FaceTime calls data files?
Yes.
Now, when reviewing the cell phone records for 704-1595, it was on in the early morning hours, a little after 5 a.m. I believe you testified previously. Does that sound familiar?
Yes.
When did it stop receiving activity? Data, calls, when did all of that stop on January 15, 2020, if you recall?
I can't recall specifically, but I want to say it was around 9 a.m.
Would it help if you actually saw the records?
Yes.
Do you see what's on this monitor in front of you?
Yes.
All right. And are these those records for the 704-1595 number?
They are.
And currently, what time is reflected on these records for January 15, 2020?
It's 11:03 UTC time. The latest and the earliest is 10:14 UTC.
So what would that equate to in Eastern Standard?
It's 5:14 a.m. for the 10:14, and for the 11:03 it is 6:03 a.m.
And then what is line 42? What time is that?
It's 12:11 or 7:11 a.m.
Line 43, the very next line for activity, what time is reflected?
18:10.
And what is that?
That would be -5, 1, 1:10.
So prior to that activity at 7:11 a.m., and then the next activity is not till 1:10 p.m.?
Sustained. Rephrase your question.
Activity stops at what time?
12:11.
Just
I'm sorry, which is 7:11
a.m.?
a.m.
And then the next activity is how many hours later approximately?
The next activity is at 1:10 p.m.
So from the period of 7 a.m. approximately till a little after 1 p.m., there was no activity on the records for that phone.
Objection, lead in. Standing objection.
Well, no standing objections here, but I will sustain the objection.
Was there any activity on the phone between the hours of 7 a.m. and 1 p.m.?
According to these records, no.
You were asked a lot of questions about different witnesses at the Merrill Road Shopping Plaza, and in this case, is that right?
Yes.
Now, in this case, was it somewhat unique that you actually had a dash cam video that captured the murder?
Yes.
And on that dash cam video, can you actually see Mr. McCormick before he is killed?
Yes.
Can you also see the shooter?
Yes.
And based on the witnesses that were on the scene, do you recall Victor Kruger?
Yes.
And are you familiar with Tashita Saunders?
Yes.
Who were the two witnesses that were the closest to this shooting?
Ms. Saunders and Mr. Kruger.
And are you aware of the descriptions they provided?
Vaguely, without refreshing my notes, looking for my notes.
But they were asked,
They were.
and they were the two closest. With regard to other witnesses that were further away, that they provided some descriptions, correct?
Correct.
And did those descriptions vary among the civilians that were at different locations, different vantage points?
Yes.
And with regard to Ms. Boston, who was at the apartment complex on Arlington Expressway, you were asked about showing her a photo spread, is that right?
Yes.
Did she indicate that she would have been able to identify the person if she saw them again?
I don't believe she did.
Would that have factored into whether or not a photo spread was shown to her?
Yes.
You were asked a lot of questions about Dominic Barner and Chris Brown. Is the only evidence in this case throughout the entire investigation that you received that brings Christopher Brown into it Dominic Barner himself?
Overruled.
Yes.
So if Dominic Barner wouldn't have mentioned Christopher Brown to you, is there any other piece of evidence that you have that would have told you he may have been involved in any way?
No.
And Dominic Barner is a co-defendant of Christopher Brown in a separate homicide case, the Damon Rothermel case. Is that right?
That's correct.
And is Dominic Barner testifying against Christopher Brown in that homicide case?
I believe he is.
And so, is Dominic Barner protecting Christopher Brown in that other case?
No.
Okay. If he knows, he can answer. Otherwise, I'll sustain the objection.
Is he a witness against Christopher Brown in the other homicide case?
He is.
Now, your investigation and the evidence that you collected in this case, does it go beyond Dominic Barner?
Yes.
Now, going back to the dash cam video for a moment, did that identify a vehicle in this case?
It did.
And what vehicle was that?
A silver Nissan Altima.
And was that silver Nissan Altima pursued out of the shopping plaza?
It was.
And it crashed?
It did.
Based on the dash cam video as well as the video surveillance you recovered from the Townsend neighborhood, how many suspects were you looking for related to the Nissan Altima?
3.
And one of those individuals you believe to be Dominic Barner,
Yes.
and he's confessed.
Yes.
So that leaves how many more suspects?
2.
How many guns were recovered in the car?
2.
And what were they?
It was a Glock handgun and an M&P rifle.
And were both of those, and let's talk about the rifle, was the rifle loaded?
Yes.
Where was the rifle located in that Nissan Altima?
The rear floorboard.
And on that rear seat, what else was located?
A white T-shirt.
And was there DNA on that white T-shirt?
There was.
Whose?
I believe it was Mr. Whitaker's.
And then in the front of the vehicle, was there something else that was located?
Another white shirt.
And what DNA was on that?
Hakeem's. Robinson, sorry.
And the firearm, that Glock that was up in the front seat, had fingerprints?
Yes.
Whose fingerprints?
Hakeem Robinson's.
So if you have 3 suspects and you remove Dominic Barner, who's confessed, and you are left with 2, how many pieces of forensic evidence or what DNA or fingerprints do you have for suspects in that vehicle?
3.
Identified.
Sorry, 3.
Take Dominic Barner out of it.
Oh, sorry, 2.
And those are for who?
Mr. Whitaker and Mr. Robinson.
Objection, mischaracterization of testimony.
Overruled.
Now, going from that Nissan Altima down further down Townsend to 1033 Townsend, Miss Buckley's residence, right?
Yes.
And how many suspects were believed to be involved in that, according to Miss Buckley?
2.
And did you get DNA results during the course of this investigation related to 2 different individuals in Miss Buckley's home?
Yes.
Who were they?
Dominique Barner and Leroy Whitaker.
Going back to a question that was asked of you regarding Miss Boston and Christopher Brown, you were shown a photograph, a defense exhibit of Christopher Brown, and asked if he had butter pecan skin tone.
Yes.
In your opinion, looking at that photograph and looking at Hakeem Robinson, do they have the same skin tone?
Roughly.
Does Barner know who the shooter is in this case?
I believe he does, yes.
Natalie Gant. There are several questions regarding her phone records, right?
Yes.
Did you receive her phone records?
Yes.
All right. And the subscriber information.
Yes.
Did you submit the correct phone records to the FBI agent to see if they could map them?
Yes.
So regardless of whether or not there is a scrivener's error on his report, did he receive the correct records from you?
Yes.
Your Honor, may I approach the witness?
Yes?
Sergeant, did you, when you received the 704-1595 number, cell phone, did you review it?
Yes.
And did you review the data that was able to be recovered from it?
Yes.
And I know that you were asked some questions regarding notes on that phone by defense counsel a few moments ago. Is that right?
That's correct.
The notes that you were shown, were there additional notes that you saw on that phone?
Yes.
Including those, or were there notes that were close in time to Charles McCormick murder?
It's closer in time than the ones he showed me, yes.
Some even from the same month?
I'm sorry.
Were there some from the same month of 2020, January 2020?
Yes.
Your Honor, may I approach the witness?
Yes?
Can you take a look at this device for a moment and tell me if you recognize that specific note, sir?
Projection, proper refreshing, I don't know if he's refreshing, impeaching. Witness didn't say, I don't know.
Okay. Is there a question that precedes this?
Do you remember verbatim the note in January of 2020?
No.
With looking at this device and allowing you to read that note, refresh your memory.
Yes.
Can you tell us when that note was made?
The note was made on January 31st of 2020.
And can you tell us what the content of that note is?
Objection,
And what's the objection?
sidebar.
All right. Let me see court and counsel. Yes.
Other than the date, just the date.
Okay. It is from January 31st of 2020.
Is that a note that is contained within that phone?
Yes.
And are there notes that are in close proximity to the time of the murder on January 2020?
Without looking at the phone, I can't say exactly.
That one of those notes in close proximity to the time of the murder?
Yes.
There were some questions regarding communications between Hakeem Robinson's Instagram account and Raekwon Howard. Do you remember that?
Yes.
And specifically, questions going back between communications into, I believe, December of 2019. Do you remember that?
Yes.
Are you aware whether or not Hakeem Robinson's mother's home was shot up in December of 2019?
And the grounds? Okay, I don't understand the relevance. I'll give you one question to try to tie it up.
In relation to the communication between Hakeem Robinson and Raekwon Howard, who are on opposite groups, right?
Yes.
I believe there were questions related to why they would be communicating kind of jovially, right?
Yes.
Was there still indications that there was friction between the two groups?
Overruled. If he knows he can answer. If not, then I will sustain.
Sorry, can you ask the question again?
Sure. So regardless of the communication taking place between Hakeem Robinson and Raekwon Howard in opposite groups, was there still indications that there was friction between the two groups?
Yes.
Did Raekwon Howard personally put out a diss song regarding Willie Addison?
No.
Who did that?
Mr. McCormick.
You were asked a lot of questions about Abdul Robinson Sr.'s email account. Is that right?
I don't know if it was his Gmail account as much as it was his Instagram account.
Okay, excuse me, Instagram account. Did you identify Abdul Robinson Sr.'s cell phone number?
Yes.
And did you actually, in fact, recover that cell phone,
Yes.
as well as cell phone records associated with that number for the time of January 15, 2020?
Yes.
And based on the records that you received for Abdul Robinson Sr.'s phone number, did you submit that to FBI so that it could be mapped as well?
Yes.
And did those results tell you exactly where Abdul Robinson Sr.'s device was on January 15, 2020?
Yes.
And did you also get video surveillance from 1430 Townsend Boulevard that captured a vehicle on January 15, 2020?
I did.
And do you recall what vehicle was captured?
An orange Dodge Challenger.
And based on Abdul Robinson Sr.'s phone records, was he anywhere near the Merrill Road shopping plaza at the time of the murder?
Objection, speculation. Hand said yes, person no.
All right, if you'll clarify the question.
Based on the cell phone records you obtained for Abdul Robinson Sr.'s phone number, was that device located in the area of the Merrill Road shopping plaza at the time of the murder?
It was not.
And the two 478 area code numbers in this case, one 478-305-9583, the other 478-491-2831, I believe.
Yes.
Those were both activated on the same account,
Yes.
and were they activated on the same day?
They were.
And the 478-491-2831 you identified as belonging to who?
Abdul Robinson Jr.
I'm sorry to interrupt you, Mr. Cooper. I have, as I've told the jury, if anyone needs to reach you in any type of emergency, we are here to receive messages and convey them to you without delay. So juror number 4 on this jury, your husband needs you to call him immediately. So we're going to take a recess. I'll let you go ahead and leave quickly first. Good. Do we have Ms. Mathis? Sorry, Ms. Mathis. And we'll go back on recess. Everyone can have their deserved break. But right during the recess, as you know, I excused both juries because juror number 4's husband needed her to call him immediately. She's just gotten word her daughter's being life-flighted to a hospital. She is upset. I could tell from when the door was open she is crying. I'll let the parties inquire if they want, but Ms. Schlax, if you'll talk to your client about what he wants to do. Was originally juror 29. That means your alternate number 2 would now be on the jury, and that is who was originally juror 62, who neither side had objections to when he was seated as an alternate. But just so if you want to look through your notes and whatnot.
No, I do remember. I want to go over it with my colleague.
Okay.
Quite frankly, the only thing
Yeah, if he can come right up here. And I may also just, you can put your hand down, sir. I might also just, once the state formally rests, just ask him if that's still the case, because obviously the state hasn't rested its case or finished the testimony of this witness. But Mr. Whitaker, you of course have been seated here throughout the course of the trial, and you've seen and heard all the testimony and evidence that the state has been presenting against you. Is that correct? And you understand that it's the state's burden to prove these two charges against you beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
That means that you do not have the burden to prove or disprove anything in this case. Do you understand?
Yes, ma'am.
That also means that you do not have to testify in this case. You have the absolute right to remain silent. Do you understand that?
Yes, ma'am.
But of course, that also means, if you wish, you have the right to testify if you choose to do so. You understand that?
Yes, ma'am.
Now, this decision of whether or not to testify or not testify is yours and yours alone to make. You have a very skilled attorney whose advice you should certainly listen to and consider. But at the end of the day, the only person who can decide whether to testify in this case is Leroy Whitaker. Do you understand that?
Yes, ma'am.
Now, if you choose not to testify in this case, I will advise the jury, as I already have, that every defendant has a right to remain silent, and that at no time is it the duty of the defendant, or I should say that at no time does the defendant or is the jury permitted to draw any inference of guilt from your exercising of your right to remain silent. Do you understand that?
Yes, ma'am.
I will also instruct them that the fact that you did not take the witness stand must not influence their verdict in any manner whatsoever. Do you understand?
Yes, ma'am.
Of course, if you choose to testify, you will be treated like any other witness. You will come forward, you will be placed under oath, you will sit in that chair where all the witnesses have been seated throughout the trial, and then you will be examined by your attorney, and then you would be cross-examined by the state attorney. Do you understand that?
Yes, ma'am.
And like with any witness, if you have any convictions for felonies or crimes of dishonesty, your credibility could be impeached with the existence of those convictions. Do you understand that?
Yes, ma'am.
Now, just so we're all on the same page, does Mr. Whitaker have any convictions for felonies or crimes of dishonesty? Okay, and that's your estimation as well, Ms. Schlax?
I think he had adjudicated as a delinquent, as a juvenile, but
Okay,
adult, not
as adult, okay.
he was only 19.
All right. So, Mr. Whitaker, have you had enough time to consult with your attorney about whether or not you wish to testify?
Yes, ma'am.
Has she answered all of your questions to your satisfaction with regard to that issue?
Yes, ma'am.
Do you need any more time to consult with her about whether or not you wish to testify? Have you made a decision about whether or not you wish to testify? And what decision have you made?
Testify.
You don't want to testify. Has anyone threatened you or coerced you in any way in order to get you to make that decision? Has anyone promised you anything in order to get you to make that decision? Are you making that decision freely, willingly, and voluntarily? Okay. In addition, Ms. Schlax has announced that she is not going to be calling any additional witnesses. She's cross-examined all these witnesses, but she's not going to be calling any witnesses in a defense case. Do you understand that? And do you agree with that decision? Were there any witnesses you wanted her to call that she's not calling? Were there any documents or other exhibits and evidence that you wanted her to introduce that she's not introducing? Have you been satisfied with her representation to this point? All right. And now again, because the state hasn't formally rested, once they rest and once we come back together for what's called the judgment of acquittal argument, I'm going to just ask you one last time to make sure you haven't changed your mind and that you still do not want to testify. You understand? All right. So, because up until that point, if you change your mind and wish to testify, you are free to do so. You understand that? Okay, then you may resume your seat. All right. Okay, we have everyone here. Is everyone ready to bring the jury out and conclude with the testimony of this witness? Yes. Okay. Then Jury's out, and let's continue. Thank you. Seats.
Oh.
You may have a seat. Oh, where's Ms. Kawas? That's right. Okay. You can have a seat, sir.
He's coming up the escalator now.
Okay. Well, may we continue with the redirect since that was your witness, Mr. DeCoste?
Sure, Your Honor.
She's
Okay.
walking in now.
All right, very good. Okay, we've got both Mr. Atkinson and Ms. Kawas, and we're going to continue then with the redirect of the witness. Go ahead, Mr. Cooper.
Sergeant, you were asked about some exhibits that are in evidence regarding Dominique Barner, photographs that were taken of him on January 15, 2020.
Yes.
When Hakeem Robinson was arrested in September of 2020, there would have been a booking photograph taken of him at that time as well, right?
Yes.
And additionally, during the course of the investigation, based on cell phone exams and other records that you have obtained that are in evidence, did you find photographs of Hakeem Robinson close in time to the murder of January 15, 2020?
Yes.
And did those photographs show what Hakeem Robinson looked like in January of 2020?
Yes.
And there were some questions regarding the Bang It Out video and the fact that there were guns in Hakeem Robinson's hands, as well as some other individuals. Is that right?
Yes.
The fingerprint that was found on the Glock handgun in the Nissan Altima, where was that print? Was it on the handle or was it on the slide?
I believe it's on the slide.
No further questions, Judge. Thank you.
All right, thank you. And ladies and gentlemen, let me give you one other instruction that I failed to give you before you viewed the YouTube video that has been moved into evidence as State's Exhibit number 193. That, if you recall, is the video that was lacking in audio for the most part. So, ladies and gentlemen, the court instructs you that that recording has been edited to eliminate the irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way that you view, listen to, or consider that evidence. But with the close of this witness, and I'll call upon the state. All right, ladies and gentlemen, the state has rested its case. This does require us to take up a matter, once again, outside of your presence. I promise it shouldn't take long, and then we will be continuing here shortly, but I'm going to have to ask you to once again leave your notepads on your seats and have a step into your respective jury rooms, and then we'll bring you out here just as soon as we can.
Are limited entirely to the testimony of Mr. Barner.
Oh, I'm sorry. Sir, you're free to go. Thank you.
Who never articulated an act, a word, a statement that encouraged himself, because he admits he had the intention for Charles McCormick to be killed. He never articulated that Leroy Whitaker ever said he had such a desire. And in fact, the only thing that Mr. Barner seemed to articulate was once they were at the apartment complex, he, Mr. Barner, came up with an idea that both people would shoot. And he claims that everyone agreed to that plan. But he has no specific statements coming from Mr. Whitaker as to his agreement in this plan. And most importantly, obviously from the undisputed facts of what occurred, Mr. Whitaker, even if you believe the evidence placing him there, he does not get out of the car. And so we have an unknown shooter that we have no testimony who said he was inspired or encouraged or even anything we could infer that Leroy Whitaker said or did anything to encourage somebody to get out of that Altima and shoot Charles McCormick down. Mr. Barner testified that he had the intent in the early morning hours of the 15th, that he's with Chris Brown going out to the apartment complex, that he's calling Hakeem Robinson. He does not articulate any conversation or any actions by my client that would actually constitute. And therefore, we would ask the court to direct a verdict as to that count in our favor. Additionally, Your Honor, in regards to the burglary charge, again, the testimony was that allegedly the second intruder, once again, not any real testimony of what he supposedly said or did to show any kind of intent to commit any kind of offense within the Buckley home. So we would also ask for a directed verdict as to count 2, because the only evidence of supposedly any actions, again, relies on the credibility of Mr. Barner that we would suggest to the court is so wholly insufficient that a directed verdict should be granted.
All right, thank you. State wish to respond?
Unless the court has any specific questions, the evidence is clear and the light is favorable to the state that the defendant will participate in the first degree murder as well as the burglary, assault, or battery. All elements were satisfied based on the testimony of Dominic Barner and Corral. This court has a specific question as to relevant or that.
Okay, thank you. Well, of course, as the parties know, as the attorneys are well aware, at this juncture, the court must take the evidence in the light most favorable to the state. Any issues of credibility of Mr. Barner or any other witness that has testified is strictly an issue for the jury to determine. Based upon that, I'm going to find that in the light most favorable to the state, that the state has established a prima facie case as to first-degree murder and as a principle, and burglary with an assault or battery, given not only Dominic Barner's testimony, but of course Barbara Buckley's testimony, and deny the motion for judgment of acquittal at this time. All right, I'll hear from defendant for Mr. Robinson.
Thank you, Your Honor. At this time, on behalf of Mr. Robinson, at first, the defense would like to renew all previous motions and objections, including any motions that were made during jury selection. At this time, taking the light most favorable to the state first judgment of acquittal, understanding that the level at this time is a prima facie showing, and that the court must take the evidence in light most favorable to the state. The main issue in this case is whether or not the shooter in this case is in fact Hakeem Robinson. We did hear from the state's lead detective that yes, there was DNA evidence. Those in and of themselves did not place him in the car at the time of the murder, and that those were insufficient for probable cause to even make an arrest at that time. The car at that time was stolen for 2 months, so there was no way to know when those items were put in. The only evidence that they have presented that the truth is in fact Hakeem Robinson, through the words of Dominic Barner. I believe at this time that his credibility has been attacked to a point where the court cannot take the evidence that he has presented as true, and that we have sufficiently attacked his credibility, and at this time I would request the court, based on that premise, grant our first motion for judgment of acquittal with the one count to the indictment, which is first degree premeditated murder. That's the only argument I'm going to make, Judge, because I believe the state will concede that their theory is that he is the shooter, so I'm not going to make any other argument as it relates to, principle or anything like that, because that is the basis.
Okay, thank you. And likewise, again, as you've acknowledged, in the light most favorable to the state, I will find that the state has established a prima facie case as to murder in the first degree for Mr. Robinson. Again, the credibility of the witnesses, whether Mr. Barner, Abdul Sr., or anyone else, is for the jury's determination. Given that and the testimony that we've heard over the course of the week, I'm going to deny the motion for judgment of acquittal at this time. All right. Then, when we bring the jury back, I'm going to turn to Mr. Whitaker's table. I'm going to ask if Defendant Whitaker has any evidence it wishes to present. You can rest in their presence if you are not going to call anybody. And so, as I promised you I would, now, Mr. Whitaker, that the state has formally and officially rested from the moment just not too long ago that I colloquied with you, that I talked to you. Have you changed your mind at all about whether or not you wish to testify? If you could please stand, sir. Thank you. And is it still your intention that you do not want to testify in this case? Okay, sir, thank you. So, so that we don't then have to send the jury back out, do you want to make your second JOA now?
Yes, Your Honor, we would renew our motion, again pointing out to the court the credibility of Mr. Barner and the absence of any specificity or detail to give this court any kind of confidence that Mr. Barner has articulated that my client is a principal.
All right, thank you. I'll deny the second motion for judgment of acquittal. And so then when we return, as stated, Defendant Whitaker will rest in the presence of the jury, and then I'm going to turn to Defendant Robinson and ask if the defense for Mr. Robinson has any witnesses it wishes to call. So, Ms. Kawas, did you have an opportunity to check with any witnesses? Will they be testifying this afternoon?
That is what we would like, Judge. I know that there's one witness that is adamant about testifying today.
Okay.
Sergeant Howell has to testify today because he's tomorrow.
Okay.
In my opinion, they're fairly short witnesses. I would
Okay.
So if we could accommodate that. And the only other thing he was asking is about if I could get a letter from the court for his job, saying that he needed to.
Yes, we'll get him a letter. Madam Clerks, can we do that? So before we leave today, we can provide him a letter of some sort?
I apologize. We had him subpoena for yesterday and today, so if he's been like just not available, if we could just do that for the 2 days. I mean, he has our defense subpoena, but it says for the week, but I just think that he has that for Monday, if we could, if anything.
Okay, we'll excuse him for yesterday and today. Okay.
And Your Honor, my client and I would like to absent ourselves for any further testimony.
All right, since these are not your witnesses? Okay. Well, let me just confirm with Mr. Whitaker. You don't wish, Mr. Whitaker, if you'll please stand again. Of course, your case is rested. These are not going to be your witnesses. These are Mr. Hakeem Robinson's witnesses, but you wish to be absent during that part of the testimony? And you don't want your attorney to question those witnesses in any way? All right, and have you had sufficient time to talk to your attorney about that? And has she answered all your questions to your satisfaction with regard to that issue? All right, and this is for just Mr. Howell and Mr. Roberts who are going to testify today, or does this include witnesses for tomorrow?
I will reconfirm with Mr. Costa and Ms. Kawaz, but I do not anticipate any testimony that I think would be helpful to our jurors or would be helpful to our case. Honestly, we're speaking of things that have no application.
So then does Mr. Whitaker's jury even need to be here?
If we're not going to be here, they don't.
No, right, that's what, I just wanted to be sure.
Let them go. That's our primary reason.
Okay.
For absenting ourselves. And I will stay, Your Honor, because I understand that the court's going to want my physical presence at the charge conference, and Mr. Whitaker will have to stay as well to handle that charge conference.
Are we doing charge conference today?
Whatever the court wants.
Okay. Well, we'll see what time we get to, because, I have to excuse the staff as well, and it's already past 5 o'clock. But what's the state's position? I mean, if these witnesses are not being called by Defendant Whitaker, can't Defendant Whitaker's jury be excused?
Probably. It just makes me nervous. I don't know. I appreciate what Ms. Fox is saying. But we're talking about the witnesses that were at the scene. I don't know what come out.
Okay. Is that a legal objection?
It is a good objection because, we were planning on doing, for purpose, we joined these trials. And there's been no evidence that one jury is hearing something they shouldn't hear. Now, we are going to separate the witnesses for evidence, and I'm uncomfortable. I'm asking them to play into the closings, and I don't know, there's no unringing the bell if something should come up in the direct across. Suddenly, Mr. Schlack says, oh my gosh, we need that. They're not here. And I appreciate what you're saying. I'm not criticizing, I don't understand why they're not here. These trials have been tried together, they're not severed, and these are witnesses being called. We'll talk about.
Well, and if we do this, then we would need to do two closings.
Right, the state does not want to do two closings, we want to do one closing in front of both juries. And again, there's no evidence here. It's rejoined. I don't anticipate any evidence presented by Robinson that would not be admissible against the defendant. So although it may not be overly probative, it's not prejudicial. They have already, through the course of this trial, listened to a ton of evidence relates only to one defendant and vice versa. So we don't have much time, and I think we can crack through this pretty quickly. Appreciate it.
Yeah.
So I think that's, my legal objection is these defendants are joined, we're taking evidence, they shouldn't.
What is the prejudice for you to remain, Ms. Schlax, if I don't grant your request to absent yourself during this part of the trial, given that the defendants were indeed joined in the indictment to be tried together?
Your Honor, if my understanding of what they intend to present in purpose, they appear to want to attack the original description of the shooter for their ultimate argument. Some much more commensurate with my client's current size. And I don't want a jury to run away and start trying to interpret evidence over and over again. Oh, well, yeah, I keep hearing how these attorneys are talking about how the shooter is so small. I think that guy was in the car because of the blood evidence in this case, and I think he was the shooter. And so I think we're prejudicing my client based on those arguments, and it has absolutely no probative value for our jury under the state theory that they want to choose.
Okay, well, here's my ruling. They were joined in the indictment. We're going to try them together. The only reason we would separate juries out is if there were inadmissible statements from their, like brutal issues and things of that nature. That is not anticipated with these two witnesses. So I'm going to have to deny your request and ask that you stay with your client through these two witnesses here today. Okay. Are we ready to bring the jury out? Juries, yes. Okay, let's bring them out.
Judge, just briefly before we bring them out,
And what is that?
just that Mr. DeCoste told me that their intention was to use still shots from a video surveillance camera.
We're not going to use any exhibits. We're just going to do testimony.
Okay, well then,
Okay, then no issue. Do we have, I just want to be certain, we have all the state's evidence that is marked over here that's been admitted, and we have so far we have defendant Hakeem Robinson, Exhibit 1. That's all we have at the moment. What is this?
So, Your Honor, that is, and I've laid the predicate for it, that those are the call action detail notes. And we've laid the predicate with the witness that they are business records. And there are statements of all of the CAD notes, specifically the present sense impression of the Officer Graham and Officer Collins.
Just those two?
No, it's all of the CAD notes, but all of them would be present sense impression. I waived them the CAD notes.
Every caller who went in?
No, so it's only the officer's communications, to my understanding. I mean, we can redact it out, but what we're trying to bring in are the CAD notes specifically as to those two.
On a disc. So is it the audio or is it a disc of documents? I guess I don't understand. Is it the actual recording that's captured, or is it a disc containing the documents of the CAD notes?
We don't have the recording. It is the latter. It's a PDF of the paperwork.
And are you intending to introduce that through one of these two witnesses?
Well, I've already laid the foundation through Smith, so I would move to enter it in sometimes during our case in chief.
All right. Well, if it doesn't involve these witnesses, I think we can address it later, but is there an objection to this?
Yes, Your Honor. These are the notes of the dispatcher.
Okay. All right, then let's not address this yet. We're going to have to address this later if it's not involving these two witnesses. But since there's an objection, we won't admit it right now. And are we ready to bring out the two juries? State?
Yes, Your Honor.
Okay. And for Robinson? All right, let's bring the juries out. Thank you. Just for your information, ladies and gentlemen, this will be the last witness of the evening. Okay. All right, sir, if you'll please come forward and be sworn.
Yes, ma'am.
All right, be sure to sit closely to those microphones and please speak loudly and clearly into them. Thank you. Counsel, you may proceed.
Good afternoon, sir.
Good afternoon.
I take it from the uniform you're a police officer?
Yes, sir.
What's your current rank?
Sergeant.
I want to turn your attention to January 14th of 2020 at around 3 o'clock in the afternoon. Do you remember being in your department's property room on that day?
Yes.
While you were in the property room, did you see my client, Hakeem Robinson?
Yes.
Did you sit down and have a conversation with him?
Yes, I did.
Now, the case that we have before these juries happens less than right around 12 hours later, 12 to 18 hours later. I want to ask you questions about what my client looked like.
Okay.
Do you remember what his hair looked like?
Somewhat, yeah.
Now, if we can use gentleman here with the gray suit and the red shirt, would you agree that my client's hair was around the same length, maybe a little bit longer, but twisted?
Correct, yes. It was, I think, a little bit longer than that.
It wasn't dreads down to his chin?
No, not at all.
It was consistent with that type haircut where it's trimmed around the edges, twists, maybe a little bit longer,
From what I remember.
but not much longer.
From what I remember, yeah. I can't recall too much, though.
Sergeant, I have two questions for you. You had a conversation for what, maybe about a half hour with my client?
If that, yes.
Would you ever use the word slender to describe Hakeem Robinson?
I would not know.
What about short?
No.
One brief moment, Your Honor.
Okay.
Nothing further. Thank you.
Okay. Any cross?
Yes, Your Honor. Good evening, Sergeant Howell.
Hey, how are you, sir?
Good. Have you had the opportunity to view video recording at the JSO property room that shows defendant Robinson and your interaction?
Prior to coming in here?
Yes, sir.
No.
Would that help refresh your memory about how the defendant Robinson looked at the time of your interaction?
Yes.
I'm going to show you what's been pre-marked as State's Identification 10R, the videos. They have been part of discovery. I've shown you. I've downloaded it onto my computer so it makes it easier to move around. Showing you the lobby, Sergeant Howell.
Objection. This is refreshing. The witness can look at it. Ask the question again.
Okay.
Let me ask this. Does this video taken on...
Objection.
Does this video...
Okay. I need to hear the question. I mean, if...
Video.
Uh-huh.
Taken on January 14th fairly and accurately display Hakeem Robinson when he comes to the property.
All right, I'll overrule the objection to that question. That's an appropriate question.
Right here, correct. He's got a hoodie over his head, correct.
And Sergeant, as we fast forward through that video, do we see you?
Yes.
And are you in a red t-shirt in this video?
Yes.
Your Honor, this time I would move into evidence states R as the appropriate number.
Okay, any objection? All right, let me see it. All right, you ready, Madam Court Reporter? All right, ladies and gentlemen, we're going to go a little bit back out of order. We're going to go back to direct examination, and then Mr. Mizrahi will conclude his cross. Yes.
I'm sorry.
Clerk first.
I got you.
One brief moment, Your Honor, while we
All right.
mark. Your Honor, if Your Honor allows, I could lay the foundation while that's being marked.
All right, and just for the record, we're marking what? Defense Exhibit number 2?
Pre-marked is defense 3.
Okay, defense. Okay, then no need to lay the predicate. Defense Exhibit number 3 shall be marked into evidence.
Sergeant, have you had an opportunity to look at defense 3?
I don't know what defense 3 is.
All right. Did you, in the hallway before coming in here, have a chance to take a look at some videos from the property room?
Yes.
It's got you wearing the red shirt.
Yes.
It's got Mr. Robinson first getting dropped off out front, walking into the facility, going inside,
Yes.
and then you having a conversation with him and him exiting?
Yes.
All right. You reviewed that before you testified?
Yes.
And in any way, did that change the testimony that you gave in here?
No, I mean, go ahead, I'm sorry.
Hair, build, height?
Like I said, hair from what I saw from the front, correct. That's what the size of what we're saying Mr. Whitaker is.
Nothing further. Thank you, Your Honor.
All right, cross-exam, continuation.
Mr. Chairman, I published statement of defense.
All right.
Is this the laptop in HDMI?
You're good.
You're good.
Texas.
Okay. Sergeant Howard was showing you Defense Exhibit 3. Is that the defendant, Mr. Hakeem Robinson, wearing a hoodie?
Yes.
Does Defense 3 fairly and accurately depict the way Hakeem Robinson looked on January 14th of 2020?
Yes.
I'm going to show you a couple more brief ones. First of all, the lobby. Again, Defense Exhibit 3, is this the inside of the property room, Sergeant?
Yes, that is.
I'm going to fast forward just to show the jury you're generally the same build as you were at the time,
Yes.
meaning today versus
What is that?
the computer
Dennis
just
Quaid?
throws up.
Okay, sorry.
Is Sergeant, is that you in the red shirt here? And who are you talking to?
It'd be Mr. Robinson, yes, and that's me.
And then one more angle. In Defense Exhibit number 3, do we see the door here where Mr. Robinson is leaving? Got it. So we're seeing in defense 3 in the red shirt, is that you, Sergeant?
Yes,
And in front of you is Mr. Hakeem Robinson?
correct.
Sergeant, approximately what was your height and weight at the time in January of 2020?
Then was 6'3", 15".
Sergeant, was the defendant, Hakeem Robinson, was there to pick up a cell phone, correct?
Correct.
Have a moment, yeah.
Okay.
That's all the questions.
All right, any questions from Mr. Whitaker?
No, Your Honor.
Okay. Any redirect?
Yes, Your Honor. Sergeant, does that video change in any way what you saw with your own eyes that day?
No, I mean,
Mr. Robinson is not there, short or skinny?
correct.
Nothing further. Thank you, Your Honor. Thank you, Sergeant.
All right, may this witness be excused?
Yes, Your Honor.
Okay. Thank you, Sergeant. You're excused and free to go.
Thank you.
All right, ladies and gentlemen, I lied. There is one more short witness. I'm so sorry. Shorter. So we are going to call this last witness, and then we will be excused for the day. Thank you. So, defense, you may call your next witness.
Defense calls Michael Williams.
Okay.
Testimony, you gave the truth, the whole truth, and that brother truth said.
All right, so if you'll be sure to sit closely to the mic.